Okay, I am delighted on behalf of Dean Dana Bowen Matthew to welcome all of you to the Access to Justice Roundtable. Dean Matthew sends her regrets and also her enthusiasm for this project. We don't have a formal slogan or motto for the law school, but Dean Matthew has highlighted 3 words that collectively convey her goals for our school: inspire, influence, and impact. And the primary way we seek to achieve these goals is through our excellent student body, as our diverse and amazing faculty inspire them to achieve greatness, influence them by introducing them to new ideas, and encouraging them to challenge existing dogmas, and ultimately impact the world through their deeds. At the same time, the law school achieves these goals by fostering research that inspires people to consider policy questions, influences how they think about contemporary issues, and ultimately impacts the world by enabling social change. The Ethical Tech Initiative is an exemplar of how universities in general, and our GW Law School in particular, have a special role to play in considering challenging issues. The initiative is unabashedly interdisciplinary. It seeks to use technology to improve access to justice. Universities are well positioned to bring together the perspective of technologists with those who focus on law. But the interdisciplinarity of the initiative goes beyond this, bringing together lines of academic inquiry that are often compartmentalized within law schools. As the word ethical suggests, the initiative is concerned with values of fairness, due process, and transparency, concerns that form the bedrock of the American legal tradition. And as the word tech suggests, the initiative is also focused on questions such as content integrity and privacy. A principal goal is to help provide access to our civil justice system, particularly in marginalized and underrepresented communities. These are issues of special interest to us at the George Washington University Law School. We have one of the leading intellectual property law and technology programs in the country, and we have long drawn on and in return influenced agencies such as the nearby Patent and Trademark Office. At the same time, we have an ambitious clinical program that focuses on the economic and legal needs of individuals in marginalized communities. And we have many faculty who perform research on related issues. I was especially pleased to hear that a couple of our superstar faculty here today, Bob Brownice and Dawn Nunziato, are involved with this initiative. You've heard more than enough from me. Let me just take a few moments to introduce our speakers. First, we'll have Eduardo Gonzalez, who is project manager for the Self-Represented Litigation Network. He has previously worked as a video game designer on games that help self-represented litigants. In addition, we have Shirley Horng, a senior staff attorney with the Legal Aid Society of DC in the Consumer Law Unit. She has a great deal of experience representing tenants in eviction and housing conditions cases in DC Superior Court. We also have Miguel Willis, the innovator in residence at the Future of the Profession Initiative. And I must say that I love the name of the initiative and the name of the position. We need a little more creativity in our own naming of positions here in the law school. And is also executive director of Access to Justice Tech Fellows. We also have GW's Professor Toni Marsh, who is director of the GW Paralegal Studies program. She's an expert in juvenile law and the president of the American Association for Paralegal Education. Finally, with special pride, I introduce another of our superstar faculty members, Jessica Steinberg. She teaches our prisoner and reentry clinic. And in addition to authoring several important empirical studies of our court system, has testified regularly on bills concerning the rights of prisoners and returning citizens. The clinic also had a role in developing a compassionate release clearinghouse to expand representation for prisoners during the COVID-19 pandemic. Thank you all so much for gathering here today.
I would just like to thank Dean Abramowicz for the very kind introduction and words. I don't think I can say anything better than how he just put it, but I'll introduce myself. My name is Joseph Caputo. I'm a research assistant for the Ethical Tech Initiative of DC. And before I begin, I would just like to make some acknowledgements. I would like to thank one of my colleagues, Lucy Zhang, for setting up this entire event tonight. I would like to thank my other colleagues, Devin, and Garrett, who are going to be serving food and drink back there, so please help yourself. I would like to thank Christopher Fischella, a former research assistant here at the George Washington University, who helped to establish the Ethical Tech Initiative. I would like to thank Professor Robert Branas and Professor Don Nunziato for their support for establishing what we hope to become long-lasting improvements in the access to justice space. Finally, I would like to thank all of our panelists who have already been introduced for their taking the time out of their schedules to come and speak with us today. And last of all, let's just say thank you to all the audience members, both virtually and in person, who are here. And with that, we're here tonight to talk about the state of legal services in the United States and the increasing justice gap. While there are no precise numbers, there are approximately 15,000 courts in the United States. And across those 15,000 court systems, there are roughly 30 to 50 million people who have to go through the civil legal system without any form of representation. And tonight, the Ethical Tech Initiative hopes to show how, in addition to traditional resources of delivering legal services, some new innovation is needed. And hopefully these panelists can tell us some ways that we can achieve those goals. So I guess to begin, we'll start off with asking each speaker to describe how they became invested in the access to justice space, because it's, unfortunately, I don't think a very known problem. The state of civil legal services in America is particularly unknown. So we'll start with Eduardo Gonzalez at the Self-Represented Litigation Network and my former project manager.
Hey, Joseph, good to see you and good to see everyone. Thank you for having me. My first kind of approach to access to justice came from an internship I took part of when I was in law school. I worked at the New Law Lab while I was at Northeastern, and one of the first projects I worked on was designing a video game for self-represented litigants. And that really was the moment where I dove really deeply into the usability of technology, designing games or just any kind of tech product for self-represented litigants navigating court systems, but also leveraging some stakeholder engagement skills with the court services in the state and the jurisdiction, as well as the court staff that end up being the people that provide the actual help to people that don't have attorneys. And so I think ever since that moment, I really kind of understood the scope of the problem and the challenge and just how many civil legal issues actually exist and the kinds of impacts they have on people's lives. You know, it includes employment, family, housing, financial stability, and consumer protection. And so all of these things are oftentimes cases that people don't have legal representation or legal help. And so that, I think, was really the problem that I set out to learn a lot about. And over the years, I've worked in research, I've worked in stakeholder engagement and kind of capacity building for legal aid organizations and other justice system organizations working on this problem, both at state and national levels. And so I've been lucky enough to continue to have this really big national level view of the kinds of programs and initiatives people are kind of deploying in their local areas to meet legal needs. And I think it's all relatively new, right? We can talk about it a little bit later, but we're just now really beginning to understand and get data about what the problems really are and how we can actually do something about it.
Great, thank you so much, Eduardo. Next, Professor Willis at the UPenn Law.
Hello, everyone. Hopefully you can hear me well. Again, my name is Miguel Willis. I'm at the Future of the Profession Initiative at UPenn Law. How I got in this space, definitely as a law student, used to do a lot of student organizing around access to justice issues, organized a social justice hackathon where we invited and engaged a bunch of technologists in the Seattle area to address some of these problems and build solutions around it. And from that there was a lack of curriculum around some of the interdisciplinary skills in terms of solving these issues, whether it be from technology vantage point, a data vantage point, or redesigning systems, which gave me the impetus to found the Access to Justice Tech Fellows Program, which was started during my 2L year and has grown since. But the program, in essence, places law students in legal aid organizations, courts, defenders associations, and other nonprofit legal services where they develop technology-based solutions, work on projects that involve data to enhance the delivery of legal services. Happy to sit next to Joseph and enjoy a fruitful partnership with GW. Joseph was a fellow over the summer working with the Self-Represented Litigants Network. And our fellowship program is open to all law students. We train them, they participate in the training, they're exposed to a variety of speakers and mentors over the summer. We have projects and fellows placed in around 30 different states around the country. And this is going on the 6th year of the program. So can everyone hear me? Oh, okay, perfect. Just trying to keep it, this is my first hybrid lecture.
Eduardo was just saying that they were lucky to have Joseph this summer.
Yeah, oh, yes. So I look at my role as a kind of facilitator. I want to equip the future generation of lawyers to address this problem, not just with the letter of the law, but a host of other solutions as well, and equip them to go out and make their mark, whether in a variety of different legal substantive areas. And so I've been able to kind of continue that work at Penn Law. Prior to there, I was at the Law School Admissions Council. And I know some of this panel may involve reentry work, working on research on examining the policies and procedures at law schools around the country that involve students who were formerly incarcerated, and trying to get a gauge of how we can make that process for getting into becoming a lawyer more efficient and friendly. And prior to that, at Alaska Legal Services or Alaska Court System, working on a statewide project to ensure Alaskans access to justice. So, yeah.
Thank you so much, Professor Willis. Now, transitioning off of that on legal services, we have Shirley Horng of the Legal Aid Society of DC, and also the co-chair of the Public Interest Community Court System here in the DC Bar. Ms. Horng, this is the first time we've ever met, so if you wouldn't mind introducing a little bit about how you got involved in, the standard traditional delivery of legal services here.
Sure. Yeah, nice to meet everyone, and thanks for having me on this panel. So my interest in access to justice, I think, is also just the reason why I became a lawyer in the first place. I don't think I would be a lawyer if it were not for specifically the access to justice issues. I think, like a lot of people, when I was young, I was very inspired by the civil rights movement, and that seeing the law actually work, at the time I thought it was working with regard to the civil rights movement, inspired me. And then, learning about the gaps between the ideals and the promises and the actual delivery of the way our legal system works, just, motivated me even more. And so, I think finding my home specifically with civil legal services was a process. I did initially think I wanted to do civil impact litigation, and considered public defense, and then I was in a housing clinic and found that I wanted to work specifically with clients, and specifically with clients who didn't have the means to afford attorney. So that has led me to legal aid, where I've been since graduating law school 14 years ago. And legal aid, I think one of the things that is special about this particular organization is that we use, our individual cases where we serve clients informs our systemic advocacy. And so we do legislative advocacy, court reform advocacy, and class actions based on what we're hearing from our clients in individual cases. And with that, we hope to sort of chip away at this huge gap between the ideals and the actual reality of the way people access justice or lack thereof. And yeah, we're continuing to do that work every day.
Great, thank you so much. Next, Professor Toni Marsh of the George Washington University's paralegal program.
Thank you. So it's great to be here. I got involved in paralegal education right after I graduated from law school. So I was working at a criminal defense firm, but I was also teaching paralegals on the side. And I loved it. I loved paralegals and I loved the paralegal model. That was 31 years ago that I first became involved in paralegal education. And from that moment, from the moment I entered the field, it was always my professional mission to expand the role of paralegals. I felt that paralegals were underutilized, and that if they would be properly utilized, they could absolutely increase access to justice, in addition to making the whole legal system work more smoothly. And so I have always looked for ways to use paralegals to increase access to justice. Concomitant with that, I've been interested in legal models and alternate legal models. And that interest and that work took me to Tanzania and Ecuador and Indian reservations in the American Southwest, where I've studied various legal models and the way that they work in delivering access to justice, or in increasing access to justice. And we'll talk about that more, I think, later, about what I learned and what they're doing there. But that's where my interest began. Now, you may be aware or may not be aware, but there's a big movement across the country to license legal professionals, essentially paralegals, licensed paralegals. And these licensed paralegals, or these licensed legal professionals, and there's no one term, every state's got its own term, so it varies, but these licensed legal professionals will be able to actually advise clients and appear in court. They'll be able to advocate in court. Now, in very limited situations right now, it's just like family law, debtor creditor, housing, a few small things like that. But the movement is exploding, and we're going to see a lot more of that. So those are my interests, and that's what sparked my interest in access to justice.
Thank you so much. Now, finally, last but not least, we have Professor Steinberg, who is here at GW's Laws Clinic, the Prisoner and Reentry Clinic. And clinics sort of represent a traditional model. I mean, they're relatively old now, but I think it wasn't until the 1980s that clinics became an accepted form of delivering legal services, in which law students are able to help provide direct legal services to those in need. So, I guess to start off with, how did you get involved in clinical work?
Well, I'll tell you my origin story when it comes to civil access to justice first, and then we can talk about clinics, which is my first job out of law school was at Legal Aid in a housing unit. I took a job in San Mateo County, which is in Silicon Valley, a suburban area in California. And on my first day on the job, I was a brand new lawyer. My supervisor, who had hired me, she quit to take a different job. And so I was left as the only housing attorney in a county of 700,000 people, so roughly the size of DC. So as you can imagine, immediate panic set in, and it was fully justified. I spent my days sort of reading treatises, having no idea what I was doing. I would walk into court. I did intake on Tuesdays and Thursdays. I would see clients. They would tell me devastating stories. I knew that I was their only hope at representation in court to fight to defend their homes. And I would walk into court sort of bewildered and confused myself because I didn't know how to navigate the procedures. I didn't know yet how to speak to the judges, let alone how could my clients. And one of the things that struck me during these 3 years that I served as a legal aid lawyer working on evictions was, not just my own experience as a lawyer being in this courtroom with clients who were in these desperate sort of emergency situations. I mean, that was powerful enough. But perhaps even more impactful, I think, on my future career and research, and what has become sort of a lifelong interest of mine, it was seeing the rows and rows of Black and brown people, largely women, sitting in the courtroom with nobody by their side, right? I could only serve so many people. I could serve the people who got in, who were persistent enough to call that legal aid hotline again and again until they got a spot on one of my intake days. And maybe that was 5 clients per day. And so maybe 10 clients per week were being seen. But how about the rest, right? Hundreds of thousands of people going through this courtroom and without lawyers. And so that experience had an enormous impact on me. And when I left legal aid and ended up transitioning into clinical legal education, first at Stanford, where I actually supervised students who worked on eviction matters in that same courtroom where I had once been a lawyer, I felt, I had never heard of these issues in law school. So it's very gratifying to be at an event like this. And I really want to thank Dawn and Bob and the students who worked on this to bring attention to civil access to justice. It wasn't something I was taught as a law student. And I thought it was very, very important to bring these lessons to students and for students to see not only their power as a lawyer, but also to witness the chaos behind the scenes, what was happening to folks who didn't have a lawyer, to sit there in court and to sort of watch as person after person had to stand up. And the judge would look to the landlord and ask the landlord, what are the issues in this case? Tell me everything I need to know. And the tenant would get, not a fair shot. And so that's how I came into this.
Great, thank you so much. Now, I guess the next question, and this is for all the panelists, I'm going around in a circle that we've set up. I think what I'm interested in is, what do you think at the moment is perhaps the most important justice gap that is not being fulfilled? Where is the need greatest? Because there are so many areas that are encompassed in the access to justice sphere, really the entirety of civil legal systems. There are not enough attorneys, not enough legal services to really help out the people in need. So, you each have a very unique perspective on this issue. So where do you see the need being the greatest? Sorry.
Do you mind if I jump in here? And Miguel, you can obviously speak whenever, but I think one of the emerging bottlenecks is really language access. So many of the resources that are being built right now, and then layers of technology are being put on top of them, is English, and a lot of English forms are oftentimes required. And so even if we're now automating and using technology to make things more efficient, I still think we're missing that element of plain language review and multi-language access that actually gets to people's needs. And that's oftentimes unfortunately, the next step after developing some resources is that the next project will be funded for multi-language or language access, and I think that's going to become a really big challenge, especially because a lot of legal aid staff and court don't have multi-language speakers, right? There's a big gap there, and it's going to keep growing.
Great. Thank you so much, Eduardo. I mean, that definitely is a foundational issue, because no matter what your issue is in whatever other area of civil legal services, if you simply can't speak the same language as your client or the person in need, there's going to be a lack of information to even get to the people who provide the services. Professor Willis?
Yeah, I can jump in. Well, definitely, if you look out on the news, I think housing is an extremely critical issue where the lapse in eviction moratorium, we're going to be looking at a wave of evictions in the courts. People, out on the streets without adequate help, and there's clear research to show that when someone has a legal problem that doesn't get treated, that problem compounds to other problems. So the framing of the question is kind of, a little odd, because people don't experience problems in a silo, right? And when someone experiences how we describe a legal problem, they're experiencing a crisis. And this crisis doesn't stop at just the eviction or the looming eviction coming over them, but it's health. There's debt collection. There's a host of other issues. So I think during the pandemic, as we're trying to grapple with how to provide adequate services to a large number of communities and vulnerable communities, and adapting to that during the pandemic, we need to be vigilant. And it's a devastating situation right now with some of the news that's going on in housing.
I think you're right. Housing is huge. Also family law. I think there's a real crisis. 85 to 90% of people go into family law matters unrepresented. And I think what would surprise a lot of people to know is that the access to justice crisis is not only limited to low-income Americans, it's hitting the middle class. A great majority of middle-class Americans are not getting their legal needs met. So I think people might be surprised to know that it's hitting the middle class as hard as, but significantly almost as hard as it's hitting low-income Americans and rural America. So one is, area of law, and that's family. I think family is huge. Housing, you're right. And you're absolutely, there's no one area. It bleeds out as far as areas of the law. People that it affects, middle class and lower income people, basically almost everybody except the 1%. And then geographic area, rural America is really feeling that. There are counties and counties and counties in rural America where there are no legal services available.
I just want to add that zooming out a little bit with regard to the gap, and I would actually say that the gap is between the universal applicability of the law and the very narrow ways to access the law. So, the law obviously should apply to everyone, and no one is above the law, no one is beneath the law. And yet, the judicial system is set up in a way where people are expected to have lawyers, to be able to interpret the law. You have to go to law school, have a law degree. Excuse me, I'm so sorry. And then bar exam, licensing, then you have to keep up with the CLEs. There are all these barriers to being able to access something that applies to you, applies to everyone. And so I think, what Eduardo mentioned about plain language, I think that's one of the root problems, is that the language of the law is inaccessible to the vast majority of people. Lawyers have trouble understanding it. That's why we have all those case laws, because it's hard to understand. There's so many ways to interpret it. And so, I think this is, a project that would take 100 years or so, but to correct our laws, not only in substance because they're super racist, but also in the language that's used so that it's accessible and so that people can understand what they're reading. And so that we can hopefully obviate the need for lawyers, at least to a large degree.
I think this is, kind of related to Shirley's point about the use of jargon, I think, in courtrooms and how inaccessible the law is. I think our formal civil justice institutions are failing. And that's sort of a trans substantive issue. We very much have a legal system that relies on the adversary contest. And so we expect parties to be represented by counsel. At least this is the way the law is written. We expect counsel to bring forward evidence and arguments. And then we expect the judge to be impartial and to render this neutral decision based on what has been said in the courtroom. All of that falls apart when there are no lawyers in the courtroom. And I don't think this is a statistic that we've yet raised, but across all civil cases in the US, so I'm including complex litigation and torts in this statistic. Across all civil cases, 75% involve an unrepresented party. So we are largely talking about lawyerless courtrooms when we talk about civil justice. And that has just so many implications. First for the enforcement of individual rights, and I think we can see that in kind of obvious ways, right? If you don't have a lawyer, and oftentimes the judge is the only lawyer in the room and kind of bound by ethical principles not to be an advocate for any one party, you don't know what claims or defenses to raise, right? You don't know procedure. You don't know how to tell a persuasive narrative to a judge. So individual rights are an issue. But there's another big issue in civil justice, and that's the lack of law development. Because we have lawyerless courts, there are no lawyers who bring appeals. And because we don't have appeals, and I'm exaggerating by saying we have none, but only slightly, we really have no case law when it comes to major civil justice issues like housing and debt collection, and even some areas of family law. And so we don't have appellate law that kind of keeps pace with evolving notions of fairness in our society. And you can really contrast that to the criminal justice system, which has a host of problems. But one thing it does have is a robust body of appellate doctrine where the Fourth and the Fifth and the Sixth Amendment are constantly refreshed, right? And you don't see that in civil justice. And so just to give you an example of what I mean, in important questions like, can you serve a petition for a restraining order via Facebook, let's say, to get into the tech aspect of this, that hasn't been answered by an appellate court. I've sat in restraining order courts and watched domestic violence survivors say, I can't serve my abuser because I can't find him. But I know he's on Facebook. I know he's on Instagram because I saw him check in yesterday. So can I serve him that way? And the judge will say, well, I don't know, and I'm not sure. And we're relying on these statutes that are skeletal and that have been written decades ago and aren't interpreted by appellate judges. So we don't have these evolving standards, I think, that could make potentially the process more fair.
Yes, I mean, I completely agree. From my perspective, this past summer, I was able to really experience and learn a lot about the development of the civil legal system in America. And, as someone who was at the time just finished my 1L year, I can't even imagine or comprehend having to represent myself. I sat through 1L classes, struggling to understand the case law that we're being taught about. But what's so interesting is that the case law that we're being taught about, these are federal court cases, these are Supreme Court cases. These are not cases coming from state courts that represent, I think, 85% of civil legal claims in America.
99.
99, oh wow. So it's crazy how the legal profession has been structured and how we just aren't teaching our current students, like myself, what the reality of our legal situation is like.
And I think it's partly a self-fulfilling prophecy, right? Because you only get to be in a case book if you're a case, and you only get to be an appellate case if there are lawyers on both sides bringing that case. And so it's a conundrum.
I had never even thought about that point about why isn't there a lack of movement in this field? I mean, we have activists and policy and legislation reform, but we don't have anything coming out of the judiciary because we don't have anyone to bring it. Professor Willis, I know over the past summer I had the honor to meet over Zoom Professor Anna Carpenter, who has discussed a lot about this work, and particularly, has talked about how law schools kind of have to do some type of reform. And as a professor yourself, maybe you could describe, going off Professor Steinberg's point, some areas where you think the law school agenda needs to change. How can we better reflect, the reality of what our court systems are like?
Yeah, really great question. And that was a really great session that we had over the summer. One, panels like this, starting the discussion with what we try to do with the Access to Justice Tech Fellows program is help you understand, provide a level of cultural competency, certain skills that aren't a huge focus in law school, emotional intelligence, cultural competency, some of the soft skills. And that goes to the point earlier in terms of how the system is set up as adversarial. And also just a diversity of skills in general, interdisciplinary skills, right? Learning how to listen and be empathetic to, whether it's a client, whether it's, a clerk in the courthouse, but learning how to listen and understand, not always listening, trying to talk to prove a point. In addition, business skills, right? When working in the courts, a lot of the problems that courts face are process problems, right? Redesigning, law students should be equipped to know how to redesign a broken process. In Alaska, one of the things that we did with, it was a specific case type, it was like non-contested divorces. Most litigants came through the courts self-represented. And so what the courts did was relax the rules of evidence. Who's in the best position of interpreting what can go in, what can go out? The judge. Much better than a first-year lawyer. So if you relax the rules of evidence, train the litigants, go through like a 2-week kind of course on how to present evidence, they were empowered, and you didn't actually need lawyers, and they were able to present their evidence and understand how the process works. So thinking how to redesign processes to make them more intuitive. One of my contract professors used to say, just make it make sense. Like, but there's a lot of things that don't make sense coming into a courtroom. If I'm experiencing a crisis and I have no help, even just navigating how to get to a specific courtroom is sometimes can be in the same process. So how can we train future lawyers, not just to think about becoming the best, most zealous advocate, but rethinking the system and structures of the law and the processes and, rules.
Thank you. Now, everything you just said about how you can first understand how to begin to know what your problem is, how to access your problem. Even if you are aware that you have a problem, these types of challenges are, so widespread. How do you think, and maybe Eduardo, you could answer this question, how do you think there's a way for us to increase availability of just spreading messages of what type of services are available, where a person can go to seek help if they need help? Because you need to, first of all, you need to know that you have a problem, and then you need to know where to go if you have a problem. And those are two, they might sound like easy processes, but they're not. They're enormous. And so maybe you could talk a little bit about how technology can help assist that.
Yeah, sure. And I'll try and tackle different parts of the question. I think from some of the work that I've done and research that has been published about it, it's become very obvious that because of the number of court systems that exist across the US, because you have federal, state, and then like regional, sometimes circuit courts, sometimes you have like very case-specific courts. Each of them have these different rules and processes and different stakeholders and leaders involved in deciding what those laws are, that it becomes increasingly hard to really determine on like a big national level, what are these best practices and core principles that should guide, tech development or communicating to people about help services that are available. And I think one of the biggest challenges is that these initiatives and services will change depending on where you are. And so DC will have its own kind of emergency plan to respond to, getting eviction assistance to tenants in need or getting some sort of relief to landlords. But maybe DC is much faster at doing it than Maryland or Virginia, which are extremely nearby, right? And so the litigant themselves or the person that's dealing with the legal issue has to first determine what is even applicable to them. And that just becomes, a scale problem because, you'll go to other states and these states won't have as robust services or accessible services. One of the other panelists had mentioned that rural areas, for example, in some states, people have to travel an hour to get to the closest legal aid office. And so I think the first way to tackle the problem is to understand your community first, right? Understand the legal needs and how people are getting the information. And technology can help if you're able to place it and people can access it. And so it's a big question on how we really approach getting help in people's hands. One example that I can really talk about is I got to attend the Self-Help Center conference in Maryland a couple of weeks ago, and one of the initiatives that a legal aid attorney had taken was to have regular meetings with the police department, regular meetings with the school district to share referral information, to share new services that are available, and to begin building those channels with the community and community organizations that are where people seek help already. And so if there was a new program or a change in some sort of court rule or applicability of the moratorium, for example, they were able to access those community leaders right away and then set up a virtual meeting to just inform people that are already helping people with just needs. And I think that's a big challenge, right? Is not treating legal issues and legal solutions as some separate constituent thing to other emergency and public services. I think it should all be this sort of self-awareness. I think the legal aid and legal referral information should always be given to 211 and those sorts of city services so that everybody becomes more aware at a baseline what they can be looking for. And then you can begin to better see the kind of channels in the community that you can place technology solutions, that you can place new services or information. And so I would say find out the legal needs of where you're going to actually implement an intervention, and then identify the demographics of that population. What are the language needs? What are the technology access information points? And then you build the solution around them using existing community channels. And that requires community organizing, to Miguel's earlier point, that isn't oftentimes taught in law school or some of these more traditional approaches to doing legal work. I think community organizing is a big part of it, and building that kind of momentum in communities will make a difference.
Thank you so much, Eduardo. Ms. Horn, now perhaps we could follow up on that, Eduardo's point about knowing your local community, seeing as we're here at George Washington University in DC. Perhaps you could tell a little bit about what the local integration of the legal aid system is like with the rest of the other types of advocacy systems here in DC.
Sure. I'll answer that. I also wanted to just say, while it's on my mind, one of the things that the legal services community has been able to do is to make sure that the court summons has our information on it, so that when people are summoned in civil cases, they do have legal aid's phone number, they have Bread for the City's phone number, and Neighborhood Legal Services Program's phone number. And then for specific case types like debt collection cases, there's a debt collection hotline number. For foreclosure cases, there's a foreclosure hotline number. And it's through these working groups with the judges and with the plaintiff's bar, because we're often on the defense side in the civil cases, these working groups were able to get this information to people who have active cases. But there are obviously a huge category of people who have cases, who have legal issues that may not be in court, or they may not yet be in court. And so I think that that's where Eduardo's suggestion of creating coalitions and working with the communities and the institutions that people are already in regular contact with, you know, churches, family collaboratives, that's so important. And it's something that DC legal services can do and should do better. And I think another thing specific to DC, we are fortunate in that we have lots of legal service providers. There is an issue though that it's difficult to access because there's not one single point of entry. And that is something that people are currently working on because, you know, it is very disheartening. You know, people, when they apply, they are putting themselves out there to try to get a lawyer. They're saying, I'm trusting, you know, in this process that I hope I can get a lawyer, and then to be like, you know, disappointed again and again that are referred to a different place. We don't handle these types of cases, or you're over income, or, you know, all these different reasons that it might, you know, that are barriers to people getting connected to legal help. To create a single point of entry, I think, is something that we all recognize is incredibly important and that DC is actively working on right now. And hopefully that will help so that there is, you know, one phone number or one, I think even ideally like one mobile app where people could find out, is this a legal issue? You know, they put in their open, you know, it's like perhaps an open-ended question, like, what is the problem that you're having right now? And then like they can write it in, and you know, in one sentence. And then, you know, if it's a legal issue, then maybe the app will, this is, I'm just like spitballing. But like, this is sort of what I think would hopefully be an accessible way for folks to figure out how to get connected to legal services, and maybe even have like fillable self-help forms that can be generated and then, you know, downloaded and printed or electronically submitted, so that, you know, for some of these situations where it can all be done on a phone even, potentially.
Yeah, I mean, the Ethical Tech Initiative, one of the things we eventually hope to do is maybe help develop something along those lines where we can have you know, a freestanding database of legal information that's accessible to everyone, you know, simply by using a mobile application. That really is something that hopefully will increase accessibility. I mean, I can't imagine how much of a resource that can be. Professor Steinberg, I guess going off that, the clinical work that you do is specifically with prisoners, and that's a group of people with limited access to communications. And you know, personally, I work I'm interning at the Department of Corrections here in DC for their special career running, college readiness and career development program. And that program, through that, I've been able to learn about the very challenges that residents in the DOC system have in accessing legal services. They can't. They can get legal information, but unlike in some other jurisdictions, we can't provide direct legal services to that. And, you know, I guess I would say then, in your experiences working with residents and other forms of prisoners, how have they sought, because they also have civil legal issues, how have they gone about accessing help with these restricted rights?
So prisoners are in a very tough spot, and that's for a couple of reasons. If you are funded, as many or most legal aid organizations are by the federal government, you are not permitted to provide legal services to a prisoner. That's through a 1996 law, the Legal Services Corporation Act. You know, you can't provide legal services to undocumented immigrants. You can't provide them to prisoners and a whole host of other people that the legislature, that Congress at that time considered undeserving of legal assistance. And so most legal services, civil legal services agencies cannot represent prisoners. And at the same time, you might think, well, okay, but their issues are largely criminal in nature. And in fact, what I do in my clinic feels squarely criminal. I work with prisoners to seek early release from prison through various administrative and judicial mechanisms. But that's not considered criminal. Anything that happens post-conviction is technically a civil legal aid matter. You have no constitutional right to counsel. You have no Sixth Amendment rights at all. And so you are required to find your own attorney. Of course, you make very little money. If you work in prison, you're likely to make 11 cents an hour with a maximum of $1 an hour if you're one of the lucky ones. So you can hardly amass savings sufficient to hire an attorney. Yet legal aid providers can't represent you for the most part, not all, not those who take private money, but those who take federal money. Public defender offices are largely engaged in the business of defending people who have been charged with crimes and who have the prospect of going to prison, and not those who have already been convicted and are serving their terms. And so I would say it's fairly bleak. It's ridiculously hard, I would say, for a prisoner to find a lawyer willing to represent them. And it's one of the reasons that I launched the clinic that I launched, because I saw a real niche area in the law, a group of people who were really truly being overlooked by, and not intentionally by anyone, but sort of falling through the cracks, not fitting neatly into sort of any category. And on top of all of that, not having the means to communicate with people on the outside in any sort of easy way. If you're a prisoner, you don't have access to the internet. So you can't surf the web looking for a lawyer to help you, or a legal aid organization, or even, you can go to the library, but you can't look online for any information related to your problem. And so really it relies on attorneys on the outside organizing in collective ways, which I've seen. I mean, DC is an extraordinary place to be a lawyer. It's an exceptional place. It's not the norm. But here there have been numerous efforts when new laws have passed that have given prisoners opportunities for release. There have been efforts to organize pro bono attorneys kind of en masse to represent prisoners in the system. And without that effort and without that collective organizing by the bar and by the public defender service and by other attorneys, my clinic and other clinics in the community, prisoners would have no access to representation. And it's a real gap.
I've seen firsthand from my experiences just how much of a lack of services are there for residents in the DOC, and I can only imagine how much more challenging it is as you deal with the Bureau of Prisoners. Eduardo, I know that, by the way, you have another engagement at 7, so whenever you feel, please feel free to drop off, but thank you so much for your time here and your contributions. It's been amazing to have you on, and it's great to see you.
Of course, no, thank you. And if I could leave, one thought that builds on the comments that were just made, I think all of these, considerations and gaps in providing legal services, analog before you even get to technology are just simply amplified when we automate without considering, the access points, the areas where people are being dropped off from the legal help. And then you create this different and pooled hierarchy where then only the people that can access and truly use the technology well are the ones that get to benefit. And so I think when we're talking about ethical use of technology, it really requires, talking to everybody that's involved, the individuals themselves that are impacted by the lack of legal help, but also the providers that have been doing it and have seen, all of the changes that they had to do in providing, analog delivery of services and figuring out the risks that automating a process will kind of surface new risks or existing risks. And I just think that's something to think about as far as, using and leveraging technology, which has, an amazing capacity to enhance access, because you can, create a lot of access for people. But at the same time, there's this big risk that you'll amplify existing challenges to providing legal help to people. And a part of it is, the regulation of law, the roles that lawyers play, but also who is even involved in the designing of new rules or simplification. So I'll leave that thought. I'm happy to follow up with you all with specific answers to questions, and then we can share that to the audience. I'm so sorry to have to leave you all early. It was an honor to sit with the other panelists. Thank you all.
Thank you, Eduardo.
Thank you, Eduardo.
Eduardo actually just left me with a great transitionary point. That is, who can deliver services? Professor Steinberg mentioned the many constraints on legal aid organizations and on lawyers in general being able to deliver legal services. But that's only one route that legal services can be provided through. So Professor Marsh, maybe you could talk about how regulatory reform might be able to change who has the power to help with legal issues.
Well, that's a good question. So what's happening around the country in the states that are exploring, including DC, by the way, is actively exploring licensed legal professionals. All of the states that either have these programs or are considering these programs, the way that they implement them is it's usually through their state bar. And what they do is they nullify or they relax or they change or they modify the rule against unauthorized practice of law. So what they do is they allow non-lawyers to practice law. So that's how that happens. And then there is, I mentioned the licensed legal professionals, but there are other non-lawyer professionals out there, non-licensed, who can also assist. So you were talking about navigating the court system, like physically navigating the court system. There are legal navigators. There's a class of professionals called legal navigators, and they work, again, there are some states where those programs are well developed and thriving. There are other states where they're starting to dip their toes. There's other states that are considering it, but California, for example, has a well-developed system of legal navigators. There's legal document preparers or legal document assistants. And those are people that can prepare legal documents for people who already know what they need, right? They can't select the document, but I can walk into an office and say, I want to get my husband and I want to get a divorce. It's uncontested. Here's the forms we need to fill out. Will you help us fill them out? Then they do that. Then you've got that next level of the licensed legal professionals. And those are the ones that can actually select the forms and say, oh, you want to get a divorce? Oh, you don't have any kids. Oh, it's uncontested. Well, here's the forms. Here are the forms you need. And then I'll fill them out for you. And I'll take you to court and I'll advise you as to how you should, allocate your resources. Or your assets. So, there's many levels of help that is out there, and depending on what the person is trying to do, which professional you're dealing with, that will dictate what the regulation will need to be that accompanies it.
And I'm somewhat aware of efforts being made in Utah with some programs to
Right, they have a program.
debundle legal services. Unfortunately, despite me, technically living in Virginia, but going to school here in DC, I'm not too familiar with how far DC has gone.
DC is exploring it. So the DC bar right now has a roundtable committee that is exploring it. So they've held several meetings at which members of legal aid and representatives from the states. Arizona's got a program. Washington State has a program. They're sunsetting their program, which is disappointing, but that's a very long story. Utah has a program. Utah's got got a good program. And then there are many others that are considering them. But DC is in the right now. They are in the totally exploratory phase, right? They're just looking into it. They're just gathering people. So they've had people from all the different states, lawyers, judges, professors, deans of the various law schools were there. I think Dana Bowen Matthew was invited, and Naomi, I can't remember who was there. Somebody from GW Law was there. People from American were there, from Catholic, there were people, UDC, the dean of UDC was there. But anyway, right now, they're just talking about it. They're just figuring out what to do. They haven't taken any steps, but if they do, if and when they do, then what they'll have to do is change the UPL rules here to implement that.
Certainly nice to know that there's something, be going on and being developed in it. Hopefully, there's progress that's being made because,
Yep.
Paralegals with, more certification behind them and, being.
What's
able-
licensing?
License, I'm
Yeah,
sorry,
it's
licensing,
Yeah, it's
being
not
able to
certification.
practice
Mhm.
and deliver legal services would just increase the capacity of those who could provide those legal services.
That's right.
Yeah, and I would just like to add, in theory, yes, I think it's great. Practicality of regulation reform, I'm still, I think it has to be proven, right? What we have currently, the regimen of regulatory reform in the different states is largely a group of lawyers creating a program intended for non-lawyers. And let's see if this will work, right? The same, I think about 10, 12 years when unbundling was coming out, that was supposed to be the next reform of, unbundled legal services would expand legal access. That hasn't necessarily been the case, although it's helped. Paraprofessionals providing legal service has been around for a long time. With BIA accredited representatives in immigration law and in other forms. So I think as I want to see more states come in the fold of regulatory reform efforts, I think there should also be voices of critique to challenge, like what are we actually doing and what is going to be the outcome? You mentioned that Washington sunset their program of limited license legal technicians. It was mirrored in bureaucracy.
That's right. You're absolutely right.
And it ultimately didn't help the people it was intended to serve.
That's
So
right.
while on the outset, we were trying to create a program to advise paralegals to provide limited scope services to individuals, the training model was strenuous for the paraprofessionals to actually become licensed. They had to almost tantamount go through 1 year law school, then
3,000 hours of
3,000
professional-
hours. And so at the grand scheme of this, 7 years later, I think you had something close to 38 limited
That's
licensed
right.
technicians in the state,
Yeah.
and probably hundreds of thousands of dollars into this program. So while I'm all for regulatory reform efforts, I do think everything from non-attorney ownership and law firms and a host of we need to be vigilant in critiquing these programs and ensuring that they are, designed, developed, and made to actually serve the people that we are intending to serve.
I mean, you're absolutely right. I mean, these programs and Washington State was a great lesson for everyone. They were the first one out. And they are a great lesson. And all of the other programs, including DC, are looking at Washington State saying, okay, here's what we shouldn't do, right? So you're right. I mean, the training, the educational requirements, the cost of entry, the barriers to entry were just not overcomable. So, but it's evolving and learning. But you're right. We got to critique it. And I'm not necessarily advocating that this should happen. I'm just telling you what is happening. This is what's going on around the country, and it's not lessening.
Sorry.
No, go ahead.
I just wanted to add a bit of a dose of outrage to the discussion because I think it's important. I don't know how many students are in the audience. Lawyers, just to back up a bit, lawyers have almost a total monopoly over the delivery of legal services. This is not the case in other professions. So if you think of healthcare, we don't just have doctors. We don't just have people who have spent 4 years in medical school and then 4 years in a residency and then 3 years in a fellowship specializing. We also rely on nurses, we rely on medical techs, we rely on physicians' assistants, right? There is a tiered system of professionals, all of whom have their role, and all of whom are very important to the delivery of healthcare, right? You don't necessarily need your doctor who trained for 12 years to come in and give you your flu shot. That can be done by somebody else. But in law, we don't think that way. We are not only, we not only have a total monopoly over the delivery of legal services, we control that monopoly as a profession, right? There's no outside regulator or outside entity that looks at the legal profession and decides, oh, I think only lawyers should be able to play in this sphere. It's lawyers who've determined that. And I have to be honest, it's a self-serving monopoly. The bar has been very protective of the right of lawyers and lawyers alone to deliver legal services. But it really makes no sense when you're looking at the bulk of civil justice problems that we face, right? Because no lawyers want to take that work. There's no paying work in evictions. There's no paying work in debt collection. Why is this the case? Because if you are facing eviction because you can't pay your rent, certainly you can't pay your lawyer. And there are no fee shifting provisions the way there are in civil rights cases so that lawyers can take deserving and meritorious cases and expect a payout at the end, right? And so there's no paying work in the civil justice system, kind of writ large. And so we really, really need to be thinking about other solutions. And a lot of what Toni and Miguel are describing, these are failed regulatory efforts because lawyers have put their hooks into the process and said, if you want to be something less than a lawyer and still provide services, you basically kind of have to go through law school. Like, we're not going to call it that. We're just going to say it's 3,000 hours of training and $45,000 and a year of classes and all that so that you can provide advice to tenants facing eviction, but you can't actually go into court, right? So we really have to think a lot more expansively, if I'm dreaming, about how to crack open the lawyer's monopoly and let others in, because not every case requires the Cadillac level of legal assistance.
That's a great point. Yeah.
Sorry, this is Shirley. I 100% agree. And I think that in addition to, creating the equivalent of like nurse practitioners, physician's assistants in the legal context, to equip self-represented people with the tools so that they can appear on their own, because no matter what, we're just never going to have enough professionals. Just to go back to the whole medical analogy, when I have a headache, I can take aspirin or Tylenol. I don't actually need to talk to a doctor if it's just a headache. If there are all these ways that we can handle things ourselves in the health context that is not super controlled and regulated with these limited ways to access it. And it should be equivalently so in the legal context. And access to legal help is just one of the barriers. I want to just mention the default rate because the service and default rates, those are things that also are major barriers to folks accessing the legal system and defending their cases. So there are so many cases, the vast majority of debt collection cases where people just don't appear for court. And there are a variety of reasons for that. One is people don't know their rights, and that's often across the board, not just debt collection cases. But oftentimes it's just simply because they weren't properly served. And I think if there is, a technological avenue to address that, I think that would be helpful. I know geo mapping or like GPS tracking is something that has taken, steps in the right direction, but it's still not enough. There are so many times when there's an affidavit of service that just plainly is incorrect. And the plaintiff side just gets to proceed with those cases and gets their judgment. And so I think that those are times where people don't even have the opportunity to show up. They don't even know that they need legal help because they never even knew that this case existed.
Thank you so much, Ms. Horng. I think we are running close on time. So first, I guess I will ask if there are any questions either from our in-person audience or our virtual audience for our panelists up here. But if not, I guess after that, we can proceed with closing remarks of just really, what do you think are the next steps that we need to take? What are, and not some broad goals, because broad goals, I don't think really get us very far. The sight in the horizon, but what are concrete things that particularly maybe law students could do right here and right now to get involved? So first, I'm soliciting any questions.
And that the Ethical Tech Initiative can do it.
that's
Well, I really like Lucy's idea or her thoughts about creating a point of entry. Her, I'm not sure how to put it, but the fact that you raised that as an issue, and you're absolutely right. And if you could solve that, and that's something that is so solvable through technology, I think it would go a long way. I mean, I'm sorry, Lucy, Shirley's point about, creating this point of entry, a portal, a single point of entry. People that are looking for something don't even know where to begin. And there are 1,000, even if you have access to the internet, there's 1,000 phone numbers to look at, and where do you even start, right? If you call the wrong number, they're like, nope, sorry, can't help you, and they hang up, and that's the end of that. So having a single point of entry or an amassing of resources would be so helpful. And that is something that technology can solve, and it's something that law students can work on. I could see something like that being tremendously helpful.
And I also wonder, how did that information get on the summonses? Shirley talked about how some of this information, contact information got on the summonses. I wonder if you can tell us anything about that process.
Sure. So legal aid and other stakeholders, we have been working with the court, and it's basically a collection of judges and lawyers and I will admit they are generally all lawyers with the exception of court staff. Lawyers from both sides of cases, lawyers from the landlord's bar, and they're different working groups. So there's a working group for landlord-tenant cases. There's a working group for foreclosure cases. There's a debt collection and small claims working group. And those are the ways that we've been able to advance some court reform and to get these, same with language access, when things need to be translated into Spanish or if there's issues with interpreters, it's through those conversations and these meetings. And I think that the court also sends, these surveys where, and I don't know if these surveys are sent to self-represented litigants, but I think there are surveys that are sent to counsel where they're given opportunities to give feedback, and it's again that it's one of those things where the people the people who have access are all attorneys, but I think the question about what law students can do, and I know that y'all are super busy yourselves, right? You've got classes and you've got all the things that you have going on in your own lives. There are a couple things that examples that I have seen that just really blew me away and inspired me. One is Upsolve, which I'm not sure if you're familiar with Upsolve. Yes, so it's an application that it basically makes bankruptcy accessible to self-represented litigants. It's a phone app where people put in the information that's pertinent to their situation, and they don't have to have a lawyer to do this process. And it's I can share, there's a brief TED Talk. I can share the link to that in the chat. But it's like a 5-minute TED Talk about this. And I'll tell you that in DC specifically, there's a huge gap with regard to probate and estate issues. it's universal. Everyone passes away at some point. You can't escape that. And yet we try to pretend, we try to pretend that people living in poverty don't have probate issues, right? We have, it's a huge problem with intergenerational wealth and people not being able to pass on the homes that they've been able to, secure for their families. I think, creating an app like that for probate issues would go a really long way in DC specifically. And then there's another website, Illinois Legal Aid, which is basically an online legal aid service provider that has this very user-friendly website. And I'm going to include that in the chat as well. So the website is illinoislegalaid.org, and they basically make the law accessible. I mean, their homepage says, "We simplify the law so you can get justice." And so I think that these are models of what hopefully, legal services can do around the country.
I'm familiar somewhat with OpSolve, and I've also seen some other innovative tools piloted by other legal aid organizations. Pine Tree, I believe, is one, and I forget where it's based out of. But
Maine.
Yeah.
But Professor Steinberg and Professor Willis, you both work with law students, every day, and you get to interact with them. I guess, you've already seen the efforts in your clinical work and with the fellowship program of students trying to get involved to more easily, help remedy the issues that and the large unmet gap of civil legal services. But is there anything more, a simple thing, maybe something easily overlooked that could be done to better help, meet the gap?
I would recommend a couple of things. Get involved with the Court Watch. There are organizations that have as their mission to answer questions about what is happening in courtrooms, in civil justice courtrooms. Shirley could probably tell you 10 questions off the top of her head she wishes she knew the answer to, but she doesn't have the time to sit in court and see how are judges handling, default cases when the debt collector shows up and the consumer doesn't. How does that default case progress, right? How easily is that debt collector just handed the money judgment? Or is there a questioning process that ensues? I'm throwing this out there. I don't know that that's an issue in this particular jurisdiction. But law students are, I just think, tremendously equipped to sit in court and answer discrete questions that legal services providers might have and that community members might have about how the justice system works. And I think it serves a dual function, right? Because you're also educating yourself as a law student about how justice does or does not function in this space. And at the same time, you're contributing real research, actionable research that another organization could run with to improve things. The other thing I wanted to say, and it's sort of getting back to, I think Shirley was the one who made this point about plain language. I did a study with my clinic students last year on felony expungement statutes across the country. And we were looking at lots of process barriers. How hard is it to expunge your felony record in various jurisdictions? And one of the things we looked at was the readability of the statutes. And we found things like grade level 22, right? Ridiculous things that don't even exist. And then I thought, let's pull up the self-help materials, right? These pro se materials that organizations labor so hard to create and which are supposed to be a simplified guide to the process. And we ran those through the readability software. Boom, grade 15, right? A little bit better, but not much better. Self-help materials really should be at a 6th grade reading level. That's what's considered universally readable. And so, taking a stab at turning forms and self-help guides and the like into plain language, that's something a law student can do, and maybe even better than a lawyer. Because as a law student, you still remember what it's like to walk into your 1L class and not have any clue what is going on, right? Everybody is speaking a different language. And so you can easily recognize places where lawyers just fall into habits. We speak in jargon and we're not even aware of it. So I think that could be tremendous value add. Yeah.
I know firsthand the challenges of trying to write in plain language. It's deceptively hard to write something. I got to see that with some of the resources that I worked with over the past summer, but it is a challenge. And I do think, law students, as we're learning the law, how does it make the most sense to us from someone coming in with no legal background? I do think that is definitely a way that law students could get involved. Hopefully that's something that is encouraged more. And Professor Willis, I guess you have the closing word on any last thoughts that you have on how law students can get more involved.
Yeah, well, all great points from the panelists. So yes, to everything that they said, I'll just posit three points. The first is looking at law schools as labs, right? As law students being active creators in the future of the law, the future of justice that we want to see, whether that be creating an app, whether that be getting involved with the ethical tech initiative of DC, building solutions to drive and solve that problem, and creative solutions, thinking outside the box, right? Law schools as labs. Second is law schools as emergency responders. This is it's an overwhelming, devastating time right now. COVID has lasted more than 19, 20 months at this point. People are tired, people are hurt, people are suffering. And I think law students have a unique position to be exposed to a legal education, which they can actually help bring some joy into people's lives that are going through tremendous heartaches and pains, whether that be through probate, whether that be through housing, whether that be through a host of medical and legal issues. I think law schools can play a role in creating the right incentives to facilitate that, whether it be through more incentivized, rewards for pro bono hours, whether that be clinics, more clinics or additional clinics responding to discrete specific issues, a host of ways. But I remember when, right when the pandemic started, Suffolk Law School mobilized really a national effort of law students to develop self-help automated forms, something that Shirley mentioned, for all of their self-help forms in their state. And they mobilized law students to do so. And I would say the last point is law students as active creators of their legal education, right? And in most processes of consumers, we have an input in what and how the products we want are going to be. Law school, not very much, right? Really controlled by the ABA legal, the section on legal education, in terms of what classes you're taking. My class, Law, Technology, and Access to Justice, many of the students that take the course they love access to justice and social justice issues, self-selecting. ABA, if we gave students an opportunity to design, be more participants in designing the legal education, I think that would better serve the community's needs. Because I know a lot of law students that come to law school with aspirations of wanting to work in communities, wanting to serve vulnerable communities and help people get the justice they need, but somewhere along the way get buckled down and ruled in the meat grinder. And that brings up a whole issue of wellness in the professions that probably deserve another long topic. But all that to say is, and I know, Joseph, you're working on a project where you were examining curriculums around legal technology in different law schools. And, you know, when I first designed and developed the Access to Justice program as a law student, some of my faculty and professors at my law school was like, okay, well, this is cool, but it's not going to work because you're not a law professor. You're not, you know, this person who's usually designs curriculum. But 6 years later, and it did work, and we were able to still provide opportunities for law students to get experiential knowledge and help communities. So I think law students being a part of the creation and development of legal education, evolving legal education, would be beneficial.
Well, I definitely hope that during my time, I'm trying as best I can to self-select for the type of curriculum that I want, the type of work that I think needs to be done. And I would like to thank all of you for furthering my education tonight. This has been truly very helpful. I sincerely thank you all for taking the time to talk to myself and everyone else here. And I think I can easily express that sentiment for everyone else. So thank you all.
Thank you.